Boy, oh boy, was last week one saucy week when it came to employment law. From cabinet papers being leaked all the way through to the Workplace Relations and Safety Minister's announcement around what changes are to come for New Zealand. If you've heard a bit in the media, or maybe this is the first time you're tuning in, then kick back, relax, because today we're going to get into what may be coming up in the next few months to a year in the employment space. Hi everyone, welcome back to Lawlands. My name is Sanam and thank you so much for tuning in today. That's right, it was one saucy week last week when it came to employment law. It was saucy, but it wasn't that kind of saucy, everyone. Come on. It's employment law we're talking about. If you do remember last year, articles that came out, especially in News Hub, where information got leaked around these fair pay agreements and what the coalition government was repealing. And we're seeing it kind of cropping up now again. It has been really interesting, but if you did miss out on it last year, well, that's why I'm here to give you all of the details that you need to know. It was really interesting to see kind of this all play out because when it comes to our politics, it's nothing like Trump versus Biden. It's a lot more tame, I would say, compared to that. But it was really interesting to see this. Now, I'm not going to, like I say, get into the politics of things when I'm on this podcast, but it is interesting to see how these papers have been leaked. And the papers essentially said fair pay agreements would have disproportionately benefited Maori, Pacifica people, women, and young people. We're seeing the Ministry of Business, Innovation and Employment, MBIE, turn around. The CEO is saying, we're going to do a thorough investigation. We need to find out where this has come from because this is really serious. And the way that I have seen in the media, the minister's approach is basically, look, at the end of the day, these are pieces of advice that we got. We are the government. The government makes a decision. We don't need to take all of the advice that's been given to us. And that is where they've shut that down. Like I said, saucy week, but what actually is the most important and critical part of last week is the fact that Brooke van Velden, who is our Workplace Relations and Safety Minister, addressed a speech to the Auckland Business Chamber where she laid out all of the changes that are going to come in the next few months to a year now that we've moved away from this 100-day plan. So if you remember, the 100-day plan that the coalition government put forward was that we would have fair pay agreements repealed. Now we're seeing a little bit of issue coming out in the media about that. And the other side of it as well was to bring back trial periods for all. The interesting part now is what are we going to see on the horizon? What's coming up? What is happening in the future? I thought we'll break it down into what Brooke van Velden proposed. She has gone into a lot of detail in terms of the whole purpose behind this. So before we get fully into it, please subscribe, follow, keep tuning in, and definitely reach out to me and connect with me on LinkedIn. Now, let's have a look at really what's been going on in terms of this announcement. So there's key areas, like I said, that's changing. We're looking at health and safety reforms. We're looking at Employment Relations Act changes. And personal grievances as well. So the whole purpose behind this shift and this whole portfolio that's been put together is to restore business confidence and certainty. That is their aim. And the policies that have been brought into place under the Labour government were really meant to benefit workers and they were meant to help with businesses being certain, but it's actually created more uncertainty. And under the previous government, we saw that the minimum wage increased nearly twice the rate of inflation. We've also seen that a new public holiday was introduced and that causes further strain on businesses. And then we've seen that sick leave entitlements have doubled as well, which has made it harder on businesses to have certainty when it comes to staffing. Another thing that she's brought up as well, or another observation, is that there has been a clear issue between employees and employers. Employers can feel like they've been pitted up against workers because of the rights that they are getting. And then likewise with employees, they are really struggling in the market to find the jobs that they are looking for. So those are the two areas. And from there, the portfolio is set out based on those two areas or observations that have been made. So the first change that's going to come up is looking at the Holidays Act. We know for a fact, everyone out there, whether you're an employer, an employee, HR professional, manager, no matter who you are, the Holidays Act is confusing. It is so confusing. Even a couple of months ago, I did a post on LinkedIn about the fact that there's this mandatory requirement under the Holidays Act to allow an employee to take a set amount of leave if they request it, and you can meet that request. I didn't even know that existed until I saw that particular clause. So new things coming up every day, because it is a very lengthy piece of legislation, because we know that this task force in 2018 was created. What the minister is saying is that at the end of the day, the confusion and the reason why it has taken so long to get anything updated at all when it comes to this task force that has been put together in 2018 around the Holidays Act is because the changes are so complicated. What we need is to pull everything back and say the problem with the Holidays Act is that it is meant for somebody that works 9 to 5, 5 days a week, and does 40 hours in a week. It is not taking into account the people that have different working arrangements, that might do flexible working, or that might do rostered work or shift work, or anything under the sun around that. It's just not factoring that in. And the reason why this task force, when it started in 2018, just couldn't deliver what they were looking to was because of how complicated things were. What I'm taking away from this is the Holidays Act needs to fit all businesses, which we've always known is a problem. It just does not fit the hospo sector. It does not fit agricultural industries. And there's just so much complication when you're looking at how to pay your employees otherwise working days and that not being explained correctly. So that's the first port of call, is to change the Holidays Act. If I can give you my opinion, I would say, yay! I am so glad that the Holidays Act will change, and I hope it changes for the better. Anything that is less complicated and is easy to understand, huge advocate for that. I would absolutely love nothing more than that. So if the Holidays Act is changing in that direction, then I fully support that. Now, in terms of what's going to be changing when it comes to health and safety, look, it seems a little bit broad to me. I didn't understand in terms of exactly where the changes are going, but what I can say is that the minister has laid out that, look, we need to focus on systems that address making sure that workers are safe and that we steer away from compliance that focuses on basically nothing that serves a purpose. So if we've got laws in place that really doesn't apply to a lot of workers or to the scenarios that they're dealing with, then why do we even have this in the first place? So that's what she's suggesting that we move away from. And then also having a look at making sure that businesses and workers have a voice to give their feedback. So again, it's that feedback loop that they're suggesting. They want people to have laws in place that are effective and that can be understood. I had somebody reach out and comment on one of my posts recently around this particular update, and they mentioned a very valid point, that health and safety culture needs to be brought to the forefront. And I remember working in advisory, a lot of times even for companies where health and safety was integral, you would always see that health and safety would just be an added on or an afterthought. And it really is about bringing it to the forefront. So she has indicated that there will be more details about public consultation in the coming months. Like I said, I feel like the explanations around this are a little bit light. I don't think that there's too much detail in here, so it'll be interesting to see where the changes need to be made or what they're suggesting and what you suggest as well for everyone that's listening and giving their input. So the next one that we're going to have a look at is with contractors. Independent contractors is one that we do see time and time again. There is always a problem around that. And what I can say from my personal experience is that contractors can get difficult because the legal side, the employment law side, and the HR side just do not match up. And I'll explain that in a little bit. But firstly, the changes that are going to come into place, or what they're proposing to start having a look at, is that contracting is all about allowing someone to re-enter the job market or allowing them to establish their own personal business on the side of ongoing contracts so that they can just keep bringing in workflow for themselves. From an economic perspective, the minister is saying that this is a great thing. It's allowing flexibility in working arrangements and increases productivity. People are doing the work and it increases the output per hour worked. The reason why I said employment law and HR, or the relationship side or the practicality side, doesn't match up is because Brooke mentioned that most contractors are happy being in a contracting relationship. So she's saying that according to statistics for New Zealand, 1 in 20 New Zealanders are contractors. about 80% of them had a lot of control over the work that they had done. 90% of them said that they were satisfied or very satisfied with the jobs that they were doing and would prefer being employed and continue to be employed by themselves. The reason why I say that there's no match is because when I worked in advisory, I remember, and we still do it to this day, if I have any situation where I'm dealing with a contractor, the first thing I say is, let's apply the test. The test is the go-to. And when you apply the test, then you look at it and you go, yes, you're leaning more towards an employee, but the question is, does that person actually want to be an employee? And a lot of times the person doesn't. And a lot of times it's just to ensure that in practice, the relationship works a particular way, that the test might lean more towards an employee than a contractor relationship. What the government wants to do in this case, or what they're proposing here, is that they want people that are contracting to have a contractor arrangement and to have certainty about the nature of the relationship, not to have to worry or look over their shoulder if they're, let's say you're an employer that has employees and you've engaged a contractor. You don't want to keep looking over your shoulder and going, oh, maybe this is turning into an employment relationship. And likewise, for a contractor, you also don't want to be looking over your shoulder and worrying about whether this is an employment relationship and you're going to have to become an employee. That's where I believe that this will provide a lot more certainty. The issue, though, is, and what I'm thinking, what happens when contractors don't believe that they are contractors? What happens when a contractor turns around and they say, no, I'm actually an employee? Do they still have a path for recourse? Do they still have an opportunity in the eyes of the law to be seen as an employee? And so that's where I would say we still need to make sure that there is some sort of option available. And we see it with the casual employment in Australia, where after a set amount of time, the casual employee has an opportunity to convert into a permanent employee. Now, if the casual doesn't want to convert, then that's perfectly fine. They don't have to. But the option is always there once they tick over to that time frame. And another thing that's been mentioned, sick leave or parental leave can be offered to a contractor, but a lot of business owners are steering away from that because of this thing where it looks like they are more of an employee. To be able to have whatever kind of arrangement that you've agreed to and certainty around that is their aim. But we'll see where this kind of lands. The next on the chopping block, well, not fully chopped, but let's say it's going to be broken up into pieces and maybe simplified, is personal grievances. Now, we know that the personal grievance process is an interesting one. It is interesting in the sense that even though it is a pathway to get some sort of remedy, it's quite costly. And sometimes, not always, but sometimes it can actually incentivize employees to just pursue a grievance in the hopes of getting a settlement, rather than it being based on some sort of conduct in the employment relationship that has truly broken down that employment relationship. So this is where the personal grievances, instead of taking a process where, you're dealing with vexatious employees, it's about looking at how we can redo this and how we can have a look at where both parties get an opportunity to still go through a process, still go through this, but the negative effect that it can have on workers, even on a business's reputation, how do we pull that all back and get rid of that? So what Minister Brooke van Velden is proposing here is to simplify the personal grievances by including maybe a high income threshold, which means that if the employee is earning a certain salary or a certain amount of wages, then they are not able to pursue a personal grievance. The other one is to remove eligibility remedies if the employee is at fault. So if the employee has done wrong in that case, then they shouldn't be able to get certain remedies. I'm guessing compensation might be where she's headed, maybe lost wages, but we'll see. Maybe even reinstatement, but we'll see what comes out of that. Now, this, I would say, out of everything, is the most contentious one. The reason why is because we're looking at access to justice issues. People are not going to be able to access personal grievance processes potentially if they earn a certain amount and they meet a certain tax bracket. That is always going to be a concern, whether you're looking at the UK only allowing people to raise grievances after a 2-year period, or you're looking at Australia having the same kind of 167,000 something, I think it is, in terms of the high income threshold for where you can't raise an unfair dismissal claim. A lot of countries have implemented this, but it is that question of access to justice. Will someone be able to get their just desserts when they are going through a personal grievance process or when they've been done wrong? So this is where it is quite contentious. The last part, which is the most interesting, is that the frontline services, so WorkSafe, MBIE, the coalition government seems to be coming for you. Be careful, because it seems like what's happening with the last part, which is to our benefit, to be honest, in terms of employers and employees, is that they are actually going to be really focused on making sure that these frontline services are giving you your bang for your buck, essentially. Are they actually pulling through, and are they making sure that they are doing things in a timely manner, that they are responding, because taxpayer money is going into these particular services. What the minister has proposed is to actually put performance targets on each of these departments. The good thing about all of these changes that are going to be coming up is that they want your input. Everyone, not just a 9-to-5 worker that worked 40 hours a week. It's not just tailored to that. So I think that will be really critical. Well, that's it from me, everyone. Thank you so much for tuning in. Like I said, reach out to me if you want. Connect with me on LinkedIn. Thank you so much for all of your support. I hope you have a lovely day, night, morning, evening, whatever it may be, and I'll see you in the next one, everyone.